I wanted to, say hi to everybody, tell you that I am Corina Stonebanks, and I already gave you an idea of what I do. I need to do one little disclaimer because, of course, I'm a lawyer and we all have to do disclaimers. But the ethics rule of New York State require me to remind everybody that this presentation is just for information. It's not legal advice. It doesn't create an attorney-client relationship between you and I. If you contact me, that doesn't create one either. So please don't send any confidential information to me. That should only be done once an attorney-client relationship is established. And the New York ethics rules say that such a presentation might be considered advertising. So a hiring of a lawyer is a very important thing, and you should never do it based on advertising. So now that I've got those formalities out, let's talk about intellectual property. Generally speaking, intellectual property are the rights given to persons over the creations of their minds, and they usually give the creator an exclusive right over the use of his or her creation for a certain period of time. Ngozi was right to mention that it encompasses entertainment law, the arts, anything that really has to do with a creation of the mind is considered intellectual property. The main ones that I'm going to talk about today, though, are trademarks, copyrights, and patents. You'll see why I'm not just talking about copyrights and patents. This is supposed to be about protecting your brand through the registration of trademarks. That's what I wanted this presentation to be about. But intellectual property also exists with something called copyrights and something called patents, and they both actually can be applied to fashion design, fashion apparel. So I'll just get into how a little bit. Okay, first question though is, what is a trademark and how do I get one? All right, a trademark is basically your brand. It's what you call your identity to the consumer on a product or on a service, or even like the name of your company, all right? You guys all know Chanel, Gucci. There's a lot of famous houses, and that's their brand. Trademarks don't have to be registered. Trademarks can actually have legal protection just through something called the common law, which means the laws as they've developed over time, courts have said this deserves protection. Trademarks, as soon as you start to use them, you're identifying yourself in such a way, it's considered a trademark and it deserves to be protected. When you have a brand name, my little example here is the brilliant brand name of brand name. You can use the little TM symbol. I'm sure you've seen it on a lot of products in the top corner. You can do it when you're not registered. Okay, so you could do it now if you have a brand. It just simply says to the world, I'm saying that this is my trademark. I'm using it as a trademark. It's my brand. It's my trademark. Okay. It does not mean that it's registered, and we'll get to that later. Okay. The courts, if you're not registered, different types of courts will enforce your right as a trademark. So if somebody else is using your trademark, you can get some protection, but you might get protection in a very small area, the area in which you operate. Let's say if you're a dentist and you have the name of your company is Omnidental, you might be able to only protect that name within like the range of neighborhoods that you're in. Basically, there's a whole bunch of analysis that the courts will do to determine, is it yours? Did you have it first? Is it really considered your trademark? That kind of thing. And then they'll see the expanse. A trademark can be any word, phrase, symbol, design, or a combination of those, as long as they identify your goods or services. So it can be a brand name, a slogan, a phrase, a symbol, or a design. It can be your business name if you're using that name as a brand. For example, Nike Inc. owns Nike. So Nike is their brand, and they have a trademark on it. You can bet they have a trademark on it. Or you can have a business name that's different from your brand. For instance, Zara, I'm sure you know the Zara clothing line, Zara stores, is owned by a company called Inditex, but they have a trademark on Zara. Cartier is owned by, I think it's a Swiss company named Richemont, and Nike actually also owns Converse brand. So it has the trademark on Converse. Now, I'm sure you're getting there already. Don't be confused about the different types of intellectual property rights that you can have. Copyrights protect original artistic or literary works. Artistic works might be like entertainment law, and Ngozi was talking about. It could be music, sound recordings. It can be obviously books, screenplays, sound recordings, photographs, painted art. Those can all be protected by copyright. Patents are usually, when you think of patents, you usually think of something that's like functional, that has been designed with some kind of scientific element to it, like an engine or the way certain pieces go together in a fastener, something of that nature. They protect the function or the design of something, as long as it's very novel. Copyrights protect, I mentioned, original artistic or literary works. Now, how does that pertain to fashion? In the USA, copyrights will protect sketches. Remember I said it'll do paintings, drawings, art, photographs, whatever. If you do a sketch, you can have a copyright on it. You have it automatically as soon as you create it. You don't have to register it, but you can also register it. The actual sketch, the actual image is what's copyrighted. Somebody can take your sketch of this beautiful dress you've just designed and create that dress. The copyright does not protect the dress that has been made. It only protects the fact that somebody can't take your sketch and reproduce it. Let's say put it in a calendar and sell the calendar or something like that. So so that's one little aspect that it'll protect. And another one is it might protect the surface design that is on fashion, a specific type of design. It doesn't, like talking about the dress and everything, it doesn't protect like the cut of a dress. So it's pretty limited. And the reason is because copyrights is supposed to be for artistic types of works. And the law considers these to be functional items, not artistic. In Europe, however, that's not the case. It's a huge industry in Europe, and copyright laws actually do protect apparel designs. Obviously, there's been a lot of lobby from the fashion industry to try and get Congress to add new laws to protect apparel designs, but we're not there yet. Why would you want to use a copyright? Well, first of all, you get it automatically just by creating the thing, the sketch or the design, and once you put it on paper or you memorialize it in some way, and it will last the life of the creator plus 70 years if it was created after 1978, and it's inexpensive to get. If you want to register a copyright, it doesn't cost much at all. Now, I'm going to move over to patents, and I'm going to talk specifically about how they're relevant to fashion design, because you guys, I assume, are not designing engines or, jet planes or something. There's two types of patents. There's a design patent and there's a utility patent. A design patent is for things that are aesthetic or ornamental in appearance. It has to be something that is new, novel, never been done before, and it has to be unique and an intrinsic part of the appearance of that item. For instance, like the Louis Vuitton symbols and signs, the patterns, it's really an intrinsic part of whatever they sell, because they stamp it all over the place. A utility patent is for things that are functional. Now you're thinking, okay, functional, what's functional in apparel? Well, it wouldn't be a t-shirt or a dress, even though of course they are functional because they cover us. It would be something that is new, something that is unique. An example here I have is that Victoria's Secret was sued for its very sexy 100-way strapless bra. That was the trademark that they were using, or they tried to use. But there was actually a woman who had created a bra, a strapless bra, that could be worked 100 different ways that she had patented. So she was able to go after Victoria's Secret. And I don't think they went to court. I'm pretty sure she got a very nice settlement. If you want to go for a patent, you have to file it within 1 year after publicly disclosing your design. One of the problems with it is it costs a lot of money. It's not inexpensive. It will last you a long period of time, 15 years for a design, 20 years for a utility patent. But it's a cumbersome process. It's technical. You need a patent lawyer to do it, people who are really specialized in it. And it often just takes too long. It can take like 20 months for a patent to go through. By that time, fashion trends have changed so quickly that it's usually hasn't been worth the money or the time. Okay, now I'm going to go into trademarks. You can see I use my little trademark, my little TM, and then I used a circle R. The circle R is going to be very relevant because I'm talking about registering your trademark. And when you have a registered trademark, you no longer use a little TM. You announce to the world that it's registered by using the circle R. There's different types of trademarks, but for our purposes in the fashion industry, I'm going to focus in on tangible goods, so apparel and accessories and that kind of thing, and service marks. A service mark is used when you provide a service. For instance, if you have an haute couture bespoke wedding gown service that you provide, that would be a service. And if you got a trademark for that, you can call it a trademark. It's technically a service mark. So what is a trademark? A trademark identifies and distinguishes goods and services as being from a particular source. It identifies the fact that it comes from you, specifically you, and not someone else who's trying to pretend to be you. A trademark can be a word, like Nike, just the letters, N-I-K-E. It can be a phrase or slogan, which of course for Nike, we always associate just do it. It can be a symbol, the little swoosh mark, which is also trademarked, a registered trademark for Nike. The design, like you can see the unique design that's on that sneaker, can be trademarked. It's a little harder to do, but it can be done. It can be done. And a combination of any of those can also be trademarked, like registered as a trademark. This is Nike, the word with the swoosh. All right, now you're probably asking yourself, why do we care? Really, like, why am I listening to this presentation? Trademarks help a merchant, or in your case, a designer merchant, distinguish its goods from that of its competitors. It assures consumers that the goods and services come from the same source, the same producer. Consumers rely on this information when they're deciding to buy which products to buy or services to use. They come to trust the source. A trademark may be one of your greatest business assets. Coca-Cola, #1 in terms of its trademark value, it's worth $72 billion. IBM, $70 billion. Go all the way down to number 100. Harley Davidson is worth, the trademarks are worth $3 billion. In the fashion world, here's a few examples for you. #1, Nike, 36.8 billion, pardon me. Louis Vuitton, 32.3 billion, and Hermes and Gucci are both worth about 18 billion each. When you have this type of value, when you own a trademark, you have the right to a type of intellectual property that you can buy and sell. So when Nike buys Converse, you can bet that Nike spent a lot of money to have the right to use the Converse trademark. So what else is at stake? You need to take care of what your trademark is, and if you're using somebody else's or somebody else is using yours, because you risk being sued for infringement if you run afoul of the laws. That means that the courts can issue an injunction against you. An injunction means that authorities can come into your workshop or wherever you're producing and force you to stop production or stop the sale in the store, stop the distribution. They can actually destroy your property. You can get damages, which means they're going to make you pay a lot of money. You can have lost profits. You can even pay penalties if it's deemed like piracy that's bad enough. And think of how much money you spend when you launch your brand, when you make your trademark. You start up your whole company, you put your name on it, you're proud, things are moving, you're advertising. If you had the wrong name, like that wasn't allowed because somebody else is using it, you're going to lose all the money that you did at the outset for marketing, for production, for purchasing supplies, all of that, because it's going to have to come off. You won't be able to use it anymore. So let's look really quickly, and I mean really quickly, at the sources of trademark law. I mentioned to you that the courts over time said that you can have a trademark as a brand as a trademark, and you can protect it over time. It started when in the 1800s, when the courts recognized that it was, deceptive to consumers if you were trying to pass off your brand to somebody else's. It then moved from deception to emphasizing that the problem really with using somebody else's trademark is the likelihood of causing consumer confusion. So you have to protect it so that you don't allow the consumers to get tricked, to get fooled and confused. It also went into a federal statute. So there's a law at the federal level that controls the use of trademarks in interstate commerce. Interstate commerce means anything that goes from one state to another. So if you are in New York, but you're selling your clothing on your website and it goes to New Jersey, that's interstate commerce. All right, I'm going to talk to you mostly today about what I was just talking about, the federal laws, but there are state registries. There are state trademark registries. You can protect your trademark by registering on a state trademark registry. It's not very expensive. It's pretty easy. It'll help in that state or local authorities might help you to fight counterfeit. The federal level, they don't really do that. You have to fight things for yourself. Should I admit this person or you do it? Okay, right. The protection though is limited to the state. So if you're working across state lines, it's not going to help you. If you want to find a list of state registries, you can find one on the website of the USPTO, United States Patent and Trade Office. And if you want to find New York specifically, you just go to www.dos.ny.gov. It lasts about 10 years, and you can apply to renew it within 10 months, within 6 months of the end of the 10-year period. And I'm going to get to the crux of, you see what the options are. Here's the crème de la crème, the one that you want, the one that will protect you the most, federal registration with the USPTO. This creates rights to your trademark throughout the entire United States and its territories, and it keeps your trademark publicly accessible in a database that everybody can access. So everybody's going to know or should know that if they want to use a trademark, they should check there, and if they find it and you're registered, it's taken. So now the question is, how would you select a trademark to register? The important thing to do when you want to pick a trademark is you want to pick a name that doesn't violate the others. It's not likely to cause confusion for the consumers between your mark and somebody else's. So it can't be too similar. The mark has to be distinctive enough so that consumers see it as identifying the source of the goods. Again, the source is the owner of the mark who controls the nature and the quality that the products are made or that the service are given in. For example, when you see Coca-Cola and you can tell it's a legit Coca-Cola bottle, you know what's in it. You know the quality of the product, you trust it, you'll buy it thinking, okay, this is a Coca-Cola. It's not someone trying to pass it off as something that might taste bad, that might be harmful to me. You come to expect something with that name. The benefits of federal registration is you can use that R, that circle R, that shows you're registered to the world. You cannot use that R if you're not registered, or at least you should not use that mark if you are not registered. So your trademark is listed on a database, even if you've only just applied for a trademark and it's pending, it's waiting for a decision, it will show up in the USPTO so people know that you're applying for it. So it's very public, and it helps discourage people, hopefully, if it's registered, definitely, from using your trademark or by trying to come up with something that is confusingly similar to yours. It gives you the right to bring a lawsuit if someone is infringing on your trademark in federal court. And the advantage of using federal court is that they are very familiar with trademark laws and they can deal with them more efficiently, generally speaking. The registration establishes the presumption that you own it and that you have the right to use it. And you can use your registration to file for trademark protection in foreign countries. There is a treaty that was signed by over 100 countries called the Madrid Protocol. And it allows you to file your trademark once it's registered on the USPTO Federal Registry in other countries. You can also record your registration with US Customs and Border Protection. So that can help fight piracy. It'll stop the importation of goods with an infringing trademark. So those are all the benefits of registering your trademark with the USPTO on the Federal Registry. What about worldwide? I mentioned it. There's unfortunately no such thing as a worldwide trademark or worldwide registration, trademark registration. But I mentioned the Madrid Protocol. It allows you to simplify the process. Instead of having to apply in every country that you think you may want to be selling your fashion designs in, it allows you to make just one application, and you can just name the countries that you want to apply for protection in. Now, there's no guarantee that the country will accept your trademark. Every country has its own rules, but it makes the process of asking for it much simpler, because you're just filing once, not 20 times, 100 times, however many countries you want your designs to appear. Okay, how long does trademark registration last? It can last forever if you continue to use that brand, that trademark in interstate commerce. You can't just get it and sit on it and not use it. And every now and then you've got to prove to the USPTO that you are using it. It doesn't take a lot, but it does have to be done. You do it once within the 5 or 6 years after you first get registered, and every 10 years after that. If you don't do this, you could lose your registration, and you'd have to register all over again for permission to have it, and you'll have to pay for all those fees all over again. So what can you register as a trademark? We've talked about the most common ones: a word, a design, or a combination of word and design, right? Nike with the swoosh. What's most important is that your trademark must be distinctive. That means that the mark can be used to identify and distinguish products or services to which that mark is attached from other people. I keep mentioning this because this is very important. when you apply for an application with the USPTO, it's going to go to an attorney who works there. They're called examining attorneys. They are going to assess whether or not your trademark should be registered. I have to tell you, it's a bit of a subjective evaluation, unfortunately. But what they're doing mainly is seeing if your mark is distinctive. There are certain categories of marks that are stronger and weaker, that are more likely to be accepted and least likely or not going to be accepted. The strongest one is a fanciful mark. A fanciful mark is a totally invented word that means nothing if it's not attached to that product or service, like Exxon. What's an Exxon? Well, there isn't an Exxon. Exxon is like oil company, right? Kodak. What's a Kodak? There's nothing. There's no meaning for Kodak. You associate it with the product, Kodak film, Kodak cameras. Pepsi, same thing. There's no such thing as Pepsi. So when you invent something that's completely new, that is it's called the fanciful mark, and it tends to be the strongest. Are you asking me a question, Ngozi? All right.
Yes, I just wanted to flag that there are a couple of questions in the chat. So do you want to answer them now before we move forward, or do you want to hold questions to the end?
If you don't mind, I'll hold them to the end.
Okay, great. Thank you.
Okay. But I'm happy for the questions. Arbitrary marks are also pretty strong, not as strong as fanciful marks. And that's when you pick a word that has nothing to do with what you're selling. Like if you use blue for dog food, or one that everybody knows, Apple for computers. It's arbitrary, it's random, it's whatever. No one's going to look at an Apple and think, oh, that must be a computer. We do now because it's a famous trademark, a famous brand name, but we wouldn't have if we didn't know way back when. A suggestive mark is a little bit weaker. And what it does is it's suggestive of what it is your product is or what your service is. It requires you to make a little mental connection between your trademark and the actual product or service. For example, dry foot. It's dry as in not wet. Foot is feet. Oh, it's an antiperspirant for feet. SoundCloud. It's a service that stores music in a digital space. Music is sound. Cloud is the digital space. You have to. It's suggestive. It just kind of takes a couple of mental links to get there. Now, a weaker one, which is not likely to be accepted, is a descriptive mark. And that's when you just completely describe what it is. Cold and creamy for ice cream. American Airlines. Now, I know you know that American Airlines is actually a trademark, but at the beginning, all it really does or did was describe that it provides airline services in America. So that would be descriptive. Now, I'm going to talk later about how you might be able to get over that hump over time, because clearly American Airlines did. But I just want you to understand what I mean by descriptive. And then finally, the weakest and the ones that are not accepted are generic. Now, these are very interesting. Did you know that escalator isn't a word? It was a brand name. Same thing with aspirin. Aspirin is owned by Bayer. But now people just call aspirin anything that has that chemical compound in it. Cellophane also is not a word. It was a brand name once. Dry ice, heroin, videotape. These are all things that once started out as a brand name, as a trademark, but it got used so often that it just became a generic word, right? A word that represents what you think it is, like Kleenex, right? You look at this, it's a tissue, but what do we think of? What do we often say? Kleenex. Kleenex, by the way, the company that owns it had to fight to try to not render its product a generic word. And I'll talk about that a little bit later. Okay, I'm going to give you some ideas of why an examining attorney at the USPTO might refuse a trademark. What they're going to look at is if there's any likelihood of confusion for the consumer, because there is a similarity in the mark that you're submitting and one that already exists. It could be a similar sound, like it sounds the same, it looks the same, it has a meaning in a different language, or it gives the same commercial impression. You can see how the last one is a little fluid. Like, what does that mean? Sound and appearance and meaning are easier. Here are some examples that are listed on the USPTO. They said, say your mark is T Markey. That's a cute little joke they make for trademark, T Markey. If your mark is T Markey, a conflicting mark would be if somebody tried to register T Markey spelled the other way. It sounds the exact same. It's going to be considered conflicting. If your mark is T. Markey and it's just in words, but then there's T. Markey all stylized, it appears the same, and it's going to be considered conflicting. We talked about the meaning being the same in translation. Lupo is just Italian for wolf. That would be a conflict. People could get confused by that. The commercial impression is the one I find a little bit harder to really say, oh, this is a hard and fast rule for this. But it would be, for instance, City Mark. Oh, that's the same thing kind of as City Girl. Or the two designs that you can see in front of you. They kind of use the same things, and they might give the same commercial impression. Likelihood of confusion is what the examining attorney is going to look at. That wants to figure out if you're distinctive or if there's any likelihood that it's going to get confused. But that does not mean identical. The examining attorney is going to make a subjective evaluation as to whether or not it's similar. You have to pay special attention when she's doing that, because he or she is also going to look at what type of product or service you give. Again, the USPTO on its website gives some examples. Like if your goods are t-shirts and pants, and somebody else has something that sounds like your trademark, but it's they sell hats. Usually what they look at is if they're in the same class, then you really can't have a similar mark. It's going to cause confusion. Even if it's in a related class of goods, it can also possibly be problematic. Even if it's not even goods to goods, it could be goods and services. If you sell t-shirts and pants, and you have your name of your design line is T Markey, somebody has a store that sells clothing called T Markey. That's a related service, but it's still related, and you can understand why it might cause confusion. You think, oh, I can get the T Markey t-shirts at the T Markey store. So there is the possibility, though, that you can argue that it's not confusingly similar if it's in completely unrelated classes. Like if you have T Markey t-shirts, you can say, listen, no one's going to think that I run a dumpster removal service with the name T Markey. No one's going to think that the person who does the t-shirts and pants are doing something that is completely unrelated. So there's a possibility when they're not really completely the same of arguing with the examining attorney that it really is not a question where there's a likelihood of confusion for the consumer. But here's one that I wanted to focus on for designers. The law, the Lanham Act, which is known as the Trademark Act, the federal statute, actually says that you cannot have a trademark if the trademark is primarily merely a surname, your last name. In other words, Coco Chanel would under this situation not be eligible to be a trademark. Anybody's last name. And fashion designers, I know a lot of you're probably thinking of using your name. This is when you really will have to consult with an attorney, because it's a complex area of the law. And there's some suggestions that sometimes you can get away with it. For example, if you put names together, like there was a case, a litigation involving Schaub Lawrence, it was together. And the court said, well, it's not primarily a surname because it's not just someone's surname. You have to look at it together and it's a separate different thing. There are law firms, I know you know law firms use all their names. Oh, what about White and Case? Why do they get to use their names? When you use another name, you might be able to say, well, it's not referring to me. It's not just my surname. It's not primarily a surname. It has a different meaning. White and Case is a company, a law firm. There's some arguments to be made there. You might be able to say that, oh, there's some other word that's attached to it, initials. And in fact, these things are really going to sort of be subjectively evaluated by the examining attorney. So it's better if you consult with an attorney to try and get an idea if we think it's going to pass or not. But you can register your surname, your last name, if it becomes very distinctive over time. Coco Chanel, obviously, Chanel is a registered trademark. Why? Because Chanel became very distinctive over time. Nobody thinks like Chanel is, oh, just that one person. They know it's the company, the whole, oh my gosh, the makeup, the clothing, everything. It becomes very distinctive as a fashion design company. So you can, over time, argue that you can register a name. And I'm going to come back to that again. Other reasons for refusal, I'm not going to spend a lot of time on them. They might be, like we said, merely descriptive or even deceptively descriptive, like you're selling vinyl pants and the name of your brand is Authentic Leather. It can't be scandalous, disparaging, immoral. You can't just use the US flag. You can't use somebody's name without their permission. There's a bunch of different reasons for refusal. But here's one I think, again, that's interesting to the fashion industry, ornamentation. Reason for refusal is if your trademark, which could be a symbol, don't forget it can be a drawing, is merely ornamental. Again, this is a pretty subjective evaluation that's going to be made by the examining attorney at the USPTO. But I can give you an example of a lawsuit which was challenging whether or not Lululemon could register their it's like the Greek omega symbol on the outfit, on the actual clothes. They said, oh, we want to be able to trademark this design. Basically, the court said, you can't have that. People have to be able to use that. If you want to have your brand, I think I saw an example of American Eagle using the number 44. It's just an ornament or a decoration. American Eagle, yes, you can have a trademark, but using the numbers 44, other people should be able to use that. So that's an interesting thing to look at in the fashion industry, as what kind of a design or symbol that you can trademark. Okay, so is that the end of the story? If you're refused for any of these grounds, are you not able to register your trademark? Is that it? Well, not necessarily. The United States Patent and Trade Office has two registries. The first one is called the Principal Registry. All the good little patents go to the Principal Registry. They get registered. But if there's a bit of a problem, you might be able to get registered on the Supplemental Register. And guess whose name is on the Supplemental Register? Mine. Why? Because the name of my company, my law firm, is STONEBANKS Law. So what's STONEBANKS? My name's Corina Stonebanks. So it's primarily a surname. It's primarily my last name. That was the argument that the examining attorney gave to me. However, I mentioned that like Coco Chanel became distinctive over time. You can argue the same thing, and you can ask to be put on the supplemental register, or sometimes the examining attorney will even suggest it and say, look, I'll put you there for now, and in 5 years, you can come back and prove to me that it's not just your surname. Stonebanks Law is a trademark unto itself. It represents your service. It doesn't represent like just you. So the supplemental register is a way that you can be registered and at one point perhaps get moved over. So it's for trademarks that are not yet eligible for registration on the principal registry, but might be over time. It provides protection for non-distinctive marks that are capable of acquiring distinctiveness. And examples of marks that might have done such a thing are like Coca-Cola. Coca-Cola would have been seen as descriptive because it's made with ingredients that have coca leaves. IBM is literally international business machines, and that's what they did. They sell business machines internationally, so that's descriptive. American Airlines, we talked about that. It provides airline flights. So in America, it describes what it does. But these kinds of marks over time, when they become so famous, so distinctive, they could apply to go from the supplemental register to the principal register. I'm not saying that's what happened with these companies. I'm giving you an example of how something could have been problematic at the beginning and would have been eligible to move over from the supplemental register to the principal. Okay, the supplemental register and the principal register share the certain benefits together. For both, you're allowed to use the circle R. So you can basically show to the world when you put your trademark, you put the circle R, that you're registered. That is going to have the effect of most likely preventing others from registering. It prevents them actually from registering a trademark that is likely to cause confusion with yours, because now the examining attorney is going to take that new application and say, oh no, you can't take Stonebanks Law. It's already taken because you're registered. And even the fact that you're on this register, on this like federal register, it can deter others from using a similar trademark, even if they're not trying to have it registered. And it can also be used as a basis for filing a lawsuit for trademark infringement in federal court if someone else starts trying to use Stonebanks Law. Okay, however, there are some downsides to the supplemental register. Trademarks on the supplemental register have no presumption of ownership, validity, or exclusivity of the mark. So if you do get sued for infringing on someone else's mark, or someone challenges you, you have to prove those things. You can't file for those international trademarks in different countries through the Madrid Protocol. You can't be recorded with the US Customs to prevent importation of goods that are, acts of piracy against your brand. You can't use it as to say, oh, I got it first because I filed. So it can be contested, and you cannot use it. You cannot be on the supplemental register if you're not actually using the trademark. One thing that I haven't mentioned up until now is that you can, remember I told you a trademark, you have to actually use it. You can apply, it's called a 1B application for a trademark that you are intending to use. You have 6 months to show that you're going to use it. You can also file for extensions. When you are on the supplemental register, you can't do that. You have to actually be using it. Okay, so is it possible to move from the secondary to the principal register? Yes. The Trademark Act says so. Proof of substantially, exclusive, sorry, that should be exclusive, and continuous use of the mark in commerce for 5 years can be considered a presumption that the mark has acquired secondary meaning thereby providing a basis to seek registration of the mark on the principal register. So it's right there in the act itself. Okay, can I trademark an idea for a brand name? Oh wait, can I trademark a catchy slogan? I've got this great slogan I'd like to use. It's really cool. No, the answer is no. You can only use the trademark if you are using it, or if you're intending to use the mark. So you can have a great idea, you can have a catchy slogan, and it's not like domain names where you sit on the domain and you say, oh, this is mine now, nobody can take it. The trademark has to be used in commerce, it has to be used across state lines, or like I explained before, you have to show that you intend to do so within 6 months. So what are the steps to getting registration, federal registration? First thing, choose a mark. Think of something. Try and think of a fanciful mark. It's the best way. It's the strongest one. Something completely not otherwise a word or associated with anything. Then make sure that it's not going to be confusingly similar by getting a clearance search done. The best way of doing that is to go to a service, to go to an attorney who can run an exhaustive, extensive clearance search and give you an idea of the risk that it might or may not be confusingly similar to another trademark. You have to have a specimen ready. What's a specimen? That sounds gross. A specimen is an example of your product or an evidence of your service that has your trademark on it. So for a service, that's kind of hard, but I used, for example, a screenshot of my website that shows what services I provide. So it shows, obviously this is interstate because it's on a website, and it says what I do and that I will charge for it, and it has STONEBANKS Law on the website. So a screenshot will work. A specimen for clothing would be a label. You say you're selling t-shirts, you show the label that's in the back here, the one that's on the breastplate, maybe there, a tag, a hanging tag. You have to show that the mark is being used with the goods. So that's the specimen. And then that's it. You're ready to apply to the USPTO. You have to make sure the clearance search is properly done. It has to be an extensive search for similar marks that might cause confusion to the consumer. You can go to the USPTO website and search their registry. And often I get people saying, oh, I'm okay, I'm good. I checked, it's not there. That's great. It's a great place to start, because if you type in Chanel, you'll find Chanel's registered. You definitely find Chanel's registered. But let's say your great idea is something like, oh, I want Sears with 2 S's at the end. Or I want Starbucks, but instead of B-U-C-K-S, I'm going to be really clever and spell B-U-X. When you do the search, I mean, you guys already know that sounds similar, so it would be refused. But if you were to type those words in, it'll say, great, there's none. Because guess what? It looks up things that are identical, that's all. So it's a good way to start, because if you find it, you know right away that there's already one that's there. But it's not a program that can figure out for you if it's confusing, if it's possible to be confused with another trademark. That can only be done by a human being so far, by an examining attorney. Make sure to be ready, like I mentioned, that you can identify when your mark was first used in interstate commerce. It could be a receipt where you show that someone from New Jersey came and bought your dress in New York. It can be a screenshot. If you're selling stuff on Amazon, it can be that shopping cart screenshot. And like I said, you have to have the specimen. I want to circle back a little bit to apparel. Apparel has to be distinctively there as the mark, not as a decoration. So if you have, again, let's say you're T Markey, the name of your fashion line is T Markey, and you make t-shirts. If you have T Markey in a traditional spot, or on a hanging tag, it's fine. But if you have a t-shirt that has T-market, 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 all over it. That's more like the design. It's more ornamental. And that's not really proof. I'm sure you can understand why. You can go to a lot of different print manufacturing companies who will print whatever you want on the shirt. That doesn't mean that T-marquee is the source of the shirt. It just means somebody put T-marquee all over it. It doesn't serve as indicating the source of the goods. So traditional places are the breast pocket here, the back of the neck. That's the safest way to go, or a tag, a label. But again, this is a subjective kind of evaluation. There's no like definitive, oh, this is absolutely the only way you can affix a mark to show that it's a trademark. It's just something to keep in mind. So what's the expected timeline? It takes about 3 months after you register for your application to hit the examining attorney's desk at the USPTO. The examining attorney then has about 3 months to either accept, yay, or for you to get an office action, which is saying, I have some problems with your application and you need to address them, fix them. And if you do, maybe I'll accept it. You have up to 6 months to respond to that. So obviously that can create further delays. Then let's say, you put in your specimen and they're like, no, your specimen's no good. That can cause delays. But even if it doesn't, it can take, then let's say it gets accepted. Well, then your mark is going to be published in something called the Official Gazette for 30 days. And during that period of time, people can contest your application. They'd be like, whoa, I'm using that already. So that adds 30 days. Altogether, it used to be, it takes about 18 months to get without problems from start to finish. It'll obviously take longer if there's delays because things are wrong, or if you're applying for a 1B that says, oh, I'm not ready yet, but I will in 6 months, within 6 months. That can obviously make it longer. But things are even slower since COVID. And they also had changed some rules that made a bunch of people file at the same time. So they had this huge increase in volume. For example, they just raised the prices of the application. So they announced ahead of time they were going to do it. So people were trying to get the applications in as soon as possible. All right. Can a registered trademark be canceled? You've registered, you're all good. Well, like I said, it can, even if it's been approved by the examining attorney, be challenged within the 30 days that it is published in the Official Gazette. So it's possible that it's at that point in time, you get the thumbs down, or you'd have to fight for it, and you might not, you might win. But it can also be, let's say, got registered past the 30 days, and again, yay, okay, I'm registered. You can have it challenged, even if it's registered, for certain reasons. And those include the fact that someone can say, you are not using this anymore. Boy, it's been 3 years and you stopped. I haven't seen anything come out of you. If you're not using this in commerce, you don't get to keep it. And they can challenge and say that it needs to be canceled if they want to use it. It can also be canceled if over time it becomes generic. That's what happened to aspirin, to yo-yo, to cellophane. They're no longer protected as trademarks because they became generic words. And so, successful brands have fought not to become generic. So you need to stay vigilant. Between 5 and 6 years after your first registration, you have to make sure that you file your declaration of use to say, hey, I'm still using this. And then once every 10 years after that, you do the same thing. It's not a lot of work, but you got to make sure that you do it. Make sure that you use your mark in interstate commerce. Monitor, make sure nobody else is, stay aware if anybody else is trying to use a similar mark to yours, and respond if they do. Either tell them, hey, quit it, or take them to court, or whatever you need to do. And don't allow your mark to become generic. I'm going to now play for you. It's the end of the presentation. I'm going to play for you a video that was created by the brand Velcro. They were fighting the fact that their patent had expired. They, it was a functional device, right? It's two things that fit together. So it was an invention. It was a device that was patented. Patents only last a certain period of time and it expired. But they also had a trademark. They said, okay, but this is our name. So whenever you see the Velcro brand, you're getting our quality of fastener. But people just tend to call it Velcro. And it's in danger of becoming like an aspirin or a yo-yo, just a generic word. So what you need to do is you kind of have to fight, keep telling the public, this is a brand, this is a brand, this is our brand. And here, I'll just play for you what was done. I hope this will work.
We're a company that's so successful. Everywhere you go, you see the scratchy, hairy fastener, and you say, hey, that's Velcro. But even though we invented this stuff, my patent lapsed 40 years ago. Now no matter who else makes it, you still wanna call it Velcro. You think it's awesome for us, we're famous, but we're lawyers and it's causing us grief. Cause there are trademark laws being broken. It's all here in a short legal brief. And we know that this is confusing because Velcro brand is who we are. What if you call it all Velcro? We're gonna lose our circle. This is for hook and loop. This one's a hook. This one's a loop. You call it Velcro, but we're letting you. This is fucking hook and loop.
We know this seems ridiculous. It's just a first world situation.
And we made $500 million last year. Up with the terms of my last vacation. And we're asking you not to say the name. It took 60 plus years to build. But if you keep calling these Velcro shoes, our trademark will get killed. Yeah.
We aren't just doing this for us. We're doing it for all the successful brands that got so popular, people started using the brand names the wrong way. So please, remember.
If you need something to clean up your socks, do it with bleach and not with. If you have blood from a boo-boo you made, this is a bandage and not a. If you're exercising with someone you're dating, it's in like skating and not. I know that big stuff is more fun to say, but if you keep doing it, our trademarks go away. This is all hook and loop. This one's a hook. This one's a loop. You call it Velcro, but we're letting you. This is fucking hook and loop.
Okay, I hope you guys enjoyed the presentation. Where are the questions? I'm ready for your questions if you have any.
That was so great. Thank you. Thank you.
Great.
Thank you. Loved it and loved having the Velcro video. So now
That's what I meant was great, not my presentation.
No, your presentation and the Velcro video were all good. So then let me share with you the questions that we had. And thank you so much. It was, again, really engaging. So one of the questions was, what is the difference between a trademark design and a patent design?
There might not be anything different in the design other than the fact that like the actual thing that's used. It's basically, if you have a design, you can try to patent it and you can try to get a trademark for it. The design itself, there's no difference between them.
Okay.
Does that make sense?
I think so. Let me ask the listener, is that what you were asking? Is that the information you wanted? Okay.
Yes, it is. I was just curious to know this because they sounded very similar, and I wanted to know if there was a different process between applying for either or. There's
a big different process, but the actual thing, it's not that you can do one design, but not another. The requirements for a patent are slightly different, and they're narrower than they are for trademarks. And it's sort of something you don't tend to go for as much because it's harder to get. But in terms of the actual requirements of what is needed for a patent, I couldn't tell you because I'm a patent lawyer.
So a design trademark then is easier to get.
Yes.
And if I were to be doing like a collaboration, for example, with another brand or a designer, would we then pursue a trademark to get that design like solidified? Or
Well, let me back up a bit. I mean, it might be easier to get a patent for some reason. It tends to be a more laborious and technical process. It's certainly a more expensive one. And like I said, it takes quite a while before it gets approved. And the fashion trend might change by then. If you're going to create, if you want to create a patent or a trademark, whoever owns it can apply for it, and you simply apply as co-owners. You don't have to have just one owner. You just have to both agree that you're the owners.
okay. And then lastly was a lot of issues in the fashion industry is that a lot of brands face, or designer brands, I'll just use as an example, have their designs copied by, for example, fast fashion brands. However, they often lose in the court of law because for the generic designs, I guess, cannot be copied, even though if they were the original creator. So I just wanted to see your response to that, and if it would even be worth it to get a design patented or copyrighted. I'm sorry, trademarked.
I'm not sure really what you mean in this context, and forgive me because I'm a lawyer, so I nitpick and I look at particular words because they have certain meaning to me. What do you mean by a generic design?
So I'll use, for example, designer Diane von Furstenberg. She was the woman designer who invented the wrap dress. And as you know, the wrap dress is a very common style that a lot of women like to use for a number of occasions. However, her design has been used from a variety of brands, from Forever 21 to Banana Republic and so on. And so I was just wondering, in that case, should she have patented it or trademarked it? And if so, would she have been able to successfully win that in court?
So the short answer was she should do both. You should try to get the patent if it isn't, it's a functional design that is completely different, like the 100-way bra, you should go for a patent. And then you can try for a trademark based on the style, but you'd probably not be patenting the style itself, but the name that goes with the style.
Great. Thank you. Thank you. We have another question that was super helpful. Somebody is asking, when is the right time to apply for a trademark? Is it worth it when you're building your business? Or should you wait till you're established?
Excellent question, and here's why. It's a trick question. Like, there is no answer to that, because there's this really funny thing that happens, which is that if you have to show that your trademark is being used in interstate commerce, which means you've already started putting money into it, but then you might not get it. And so you've lost all the money that you've done. So you have to show that you're using it, but really it's better not to, because you might not get it. So in that case, you could go for an intent to use application and say that you're going to be actually using it in interstate commerce within 6 months. And if you don't make it within 6 months, you can apply for extensions. They usually get approved. There's no guarantee that they'll keep doing it, but it seems to be pretty okay to get extensions. So if you know that you want to use a brand, I would try to apply sooner rather than later. There's going to be costs associated with it. You have to pay the fees at the USPTO, which I would, just as a rough guesstimate, say that they would come up to maybe $500. But it did, because it depends on what you're doing. If you need extensions, it costs a little bit more, that kind of thing. But then you have to pay the lawyer's fees. So that's an investment that you would make in something, but hopefully you will have done a clearance search and you will have something that you're fairly confident will get accepted. There's no guarantee, because like I said, it's a subjective evaluation that's done by the examining attorney. But an attorney should have a good idea of telling you where it might land on the scale. So I'd say it's much better to make that investment early on so that you don't pour money into something that you have to throw down the drain.
Thank you, thank you. And so then we have another question, it's a really good question. Is this similar to copyright for music?
Well, it's intellectual property that's protected. The only difference is copyright for music is artistic copy. Like I said, in artistic copy, that made no sense. That the product that is being given rights to, copyrights, is artistic. It's creative. And like I said earlier on in the presentation, you can get a copyright for the art, some aspects of the fashion design, but in the United States, it's very narrow as to what you can do. Sketch can be protected, not to be reproduced. But it's pretty narrow. But it's similar in the fact that there's two things that are similar. When you have a copyright in music, as soon as you create the music, you write it down on paper or you record it, it automatically has a copyright. When you have a trademark, you have a brand name, and you start using it in commerce, you automatically have a trademark. The difference is that someone can challenge your use of that trademark if they're using it. And then the trademark can be registered and the copyright can be registered. So there's some similarities there.
Okay, thank you. Then we had one last question. That question is, which is more beneficial, a patent or a trademark?
Trademark will last longer. So the patent has a certain life expectancy. It was depending on what it was, if it was the functional or the design. I think it was 15 and 25 years. Now I don't even remember what I wrote down. Whereas you can keep, with a trademark, you can keep applying to every 10 years to show that you're using it to keep it.
So that means every 10 years, Coca-Cola has to reapply for their trademark?
Yep. And they do.
Okay.
Oh, no, I'm sorry. No, I'm sorry. They don't reapply. They don't reapply. They just attest to the fact that they're still using it in interstate commerce. They're just signing an attestation that they're still using it in interstate commerce.
Okay, then they have to send that to.
Can be challenged by someone to say, no, you're not. And then it could be risk that it'll get canceled because the trademark is considered, and then the trademark will be considered dead. By the way, that's something that's also very interesting. When you look on the registry, the USPTO registry, you see applications that are pending, that are live and they've been accepted, and applications that are dead.
Okay, and so then if an application is dead, somebody else can apply for that using something similar or closer.
You can take something that's dead. You're still going to have the same hurdles to make sure it's not confusingly similar to anything else, but you can take it. And one caveat is that within a certain period of time after something is dead, the USPTO still gives you a chance for 6 months or something to try to revive it.
Okay.
So if you see something's dead, make sure it's dead. It's not recently dead.
And not during the grace period dead when it can be resurrected.
Exactly. The resurrection possibility is not a good one. Yeah.
Okay. Great. So I think that is all of the questions. Does anybody else have any other questions?
My last question is, are we able to reach out to you if we have any additional, more like specific questions?
If you want, you can reach out to me and we can schedule a complimentary consultation for 15 minutes. I can sort of explain more of what's going on, of what what I've already explained. I can answer questions on that. I won't be able to, in that 15-minute period of time, tell you exactly what you should do in your situation and provide legal advice in that. But I can certainly, speak to you for 50 minutes or so and see maybe help in what direction you might be looking at.
Great, that's super helpful. So if anybody wants to schedule time, just email me, Ngozi@Custom Collaborative, and then I will pass the information along to Attorney Stonebanks. Okay, and it looks like,
thanks to you.
yes, for sure. It looks like we have one last question.
Okay.
Christina's asking, can a person apply for a patent and a trademark at the same time?
Yep. You can do a patent, copyright, and trademark all at the same time. They have nothing to do with each other. They don't step on each other's toes in any way.
Thank you. Okay, but my question is about that. Go be the same time the result, like they go answer me about 1 year, both take same time to approve.
No, there's copyright happens really fast. You can register very quickly for a copyright. It's very easy to do. Patents take a longer period of time usually, but trademarks are taking quite a long time lately because of all the backlog. But it doesn't matter what order. I mean, it does matter, but you can get them in any order you want. It's not like, oh, I have to get my trademark before I get my patent or before I get my copyright. That doesn't matter in terms of what's allowed. It has legal repercussions, because a trademark is different than a patent and is different than a copyright, but you're not obligated to do it or get them in any specific order.
Thank you so much.
You're welcome.
And so I keep thinking this is our last question, but we have one last question.
Okay.
One last one. And so then the question is, do you pay taxes? I guess that it means like, do you pay taxes on the value of your intellectual property? But maybe the person can explain a little more. Do we pay taxes on which? So Beverly asked if you have to pay taxes. Beverly, do you mean, which do you mean, do we pay taxes on what?
For the patent or the other one? I mean, you know how certain things, okay, when you're doing a business, you have to, at the end of the year, of course, you have to register with IRS, and then you have to pay, I think, a certain amount with the taxes. So this is what I want to know. Do you have to with that?
Okay, I'm not a tax lawyer, but and you should definitely speak either to an accountant or a tax lawyer about it if you want to know. But my inclination is to say no, because it does not in itself bring in revenue. So you need to have income from it, and the income would only be if you were to sell it. If you sell it, because it's like when Nike purchased Converse sold for so many million. So that would be a sale of an intellectual property, but it still would be revenue for the person selling it.
Okay.
That sound right to you, Ngozi?
Yes, it does.
Thank you.
You can only pay tax on something that has value, and it might not have value at the time. Okay. Thank you. This has been a really robust conversation. We appreciate your information, not legal advice. And we thank you again. And you'll probably be hearing from us soon for people who want to have consultations.
Okay. Good luck to everybody. Thank you very much for
Thank
having
you.
me.
Thank you.
Bye.
Thank you.
Bye-bye.